1, 2, 3 test, 1, 2, 3 test. This is a test for the English captioning. 1, 2, 3 test, 1, 2, 3 test. This is a test for the English captioning. 1, 2, 3 test, 1, 2, 3 test. 1, 2, 3 test, 1, 2, 3 test. This is a test for the English captioning. 1, 2, 3 test, 1, 2, 3 test. One, two, three test, 1, 2, 3 test. This is a test for the captioning. 1, 2, 3 test, 1, 2, 3 test. Test conclusive. Thank you. Un, deux, trois tests, 1, 2, 3 tests. Ceci est un test pour le captioning français. 1, 2, 3 tests, 1, 2, 3 tests. Ceci est un test pour le captioning français.
Afternoon. We have a full speakers list remaining for item 3, so we'll be starting to call the list of speakers shortly after an important announcement from the Secretariat.
Good afternoon, everyone. I hope you're all listening to what I'm going to say. I have an announcement to make and a reminder that according to UN rules, the use of photography or other forms of recorded equipment is prohibited in room 19, except for accredited members of the media. That includes social media, TikTok, Facebook Live, and any sort of recording, please. We ask you to abide by those rules, otherwise we'll have to ask you to leave the room. That's as far as rules are concerned. I would like to also inform you that applications for vacancies of mandate holders of EMRIP, Asia member of EMRIP, and the Arctic member of EMRIP are now open on the website of the Human Rights Council. Feel free to apply or share those vacancies with those who might be interested. Thank you. We go back to item 3. Thank you.
Thank you, Belen, for those important announcements. So returning to the speakers list, I'd like to give the floor to the representative from Argentina.
Presidente.
Thank you, Chair. The National Institute for Indigenous Issues, together with the state of Argentina, it has been created 40 years ago, and their official registers with the official documents with the legal persons involving indigenous persons and the confirmation of their subjects of collective rights. Information on 39 peoples that have been recognized and 1,200 communities are in a position to be consultant, and it documents different administrative procedures and the history of indigenous peoples, the steps in their evolution and their self-recognition. I also like to say that we have started the process of updating the information related to different communities as well as the elected representatives through their own participative and community systems created by through their own statutes as a reflection of internal order of the communities. Also, we are implementing a single database that includes official information related to indigenous peoples, differentiated by peoples, including the different actions, the requirements, and also requests that were made, all in line with the guaranteeing institution. Also, you also find organizations that are involved in processing open information, making it possible to access public information as a transparency steps related to any actions taken by the government. We will continue this work related to the collection of data in cooperation with all institutions of the government as part of the Federal Council on Indigenous Policies and also the Council on Indigenous Participation established by law. Thank you.
I thank the representative for your intervention. I now give the floor to Chief Littlechild. Sorry, I give the floor to the ILO.
Thank you, Chair. We would like to congratulate you and the Vice Chairs upon your election. And we welcome and we thank the EMRIP for having prepared a study on collection of data and data disaggregation in respect of indigenous peoples. Indeed, appropriate data is essential for making effective public policies for the realization of the rights of indigenous peoples. The draft study appropriately refers to ILO Convention 169 as of being of direct relevance to the subject of the study. Indeed, when countries ratify the convention, they are invited to submit to the ILO and to the ILO supervisory bodies disaggregated data and statistics concerning the demographic size of the peoples concerned and where they live. In addition to Convention 169, this is also relevant for a range of other ILO conventions, including the Discrimination in Employment and Occupation Convention. Official statistics and community-based data, such as data collected through tools like the indigenous navigators, can usefully complement each other in this context. Indeed, the ILO Committee of Experts has stressed that both disaggregated data and qualitative research on the nature and extent of labor inequalities, including their underlying causes, are crucial to determine the nature, extent, and causes of discrimination, design and implement relevant and effective policies, and monitor and evaluate their results. A recent review of labor force and household surveys implemented by our member states, by our 187 member states, revealed that currently 47 countries collect and disclose ethnicity data with varying levels of details and availability. This underscores the need for further improving data collection and reporting of such data at a global scale. In addition to looking at disaggregation techniques, this is a matter for statistics and methodology, and also finding the right way of identification of indigenous peoples in data by relying on the principle of self-identification. Another recent ILO study also shows that designing relevant statistical indicators is equally important, and this was done by examining the potential use of labor statistics that is being already collected for monitoring the exercise of indigenous peoples' traditional occupations and related developments. We have submitted a written statement which has detailed references to our work and our studies, and we hope that this will assist the EMRIP also in finalizing your important study. Thank you very much.
I thank the representative from ILO for your intervention. I'd now like to return to Chief Littlechild. Chief, you have the floor.
Thank you very much. Nigan Gakyo Tatamskad no, not authentic. This is a joint statement, and thank you very much. Respectful greetings to all delegations through you, Madam Chair. Your Excellencies and esteemed members, Indigenous peoples continue to face systematic barriers in data collection, access, control, and protection. Many still do not have basic internet connectivity or the infrastructure required for data collection and management. Where access exists, high rates of illiteracy limit accurate data gathering and effective participation difficult. All data collection must be based on true, free, prior, and informed consent. Indigenous peoples, tribes, and nations have the right to the integrity and protection of their intellectual property, sacred and culturally sensitive information, including data about sacred sites and sacred traditional knowledge, and where necessary, for this to be removed from public access entirely. Critically important is the protection of intellectual property rights, including safeguarding Indigenous languages, sacred writing systems, such as Cree syllabics, Chakpeikana, as we say, and the ceremonial knowledge contained therein. Efforts to preserve Indigenous languages must also include protection against unauthorized use. The states, United Nations systems, and public and private corporate actors share responsibility and obligations to ensure Indigenous peoples, tribes, and nations data collection, control, and protection are fully implemented and supported through adequate, meaningful, and ongoing measures, including respecting our sacred protocols. While protocols vary, in our Cree way, traditional and customary laws set out the rules for protocol that must be respected as sacred ceremony, an integral part of our spirituality. Data collection, interpretation, and training must also honor the original spirit and intent of Treaty Number 6 in 1876 and adhesions thereto, as understood by Indigenous peoples themselves. And this is affirmed in the American Declaration on the Rights of Indigenous Peoples, Article 24. This is necessary to prevent misinterpretation, misinformation, and the erosion of our sacred treaty rights. To save time, Madam Chair, we will submit all of our intervention, but lastly, we call for action on two matters. States, corporate actors must prioritize investment into all levels and forms of data systems and infrastructure so that Indigenous peoples are included and visible. Lastly, consider experts a follow-up study specifically on artificial intelligence, its uses, impacts, and its role in upholding the UN Declaration and the implementation of the international Indigenous legal framework. Thank you very much, Madam Chair.
I thank Chief Littlechild for your intervention. Much appreciated. I now give the floor to the Chair of the Permanent Forum.
Thank you. First, let me allow congratulations to the new chair and the vice chairs. The United Nations Permanent Forum on Indigenous Issues has consistently emphasized the critical importance of Indigenous peoples' data in advancing the rights and well-being of Indigenous peoples. In 2004, the forum facilitated a workshop on data collection and disaggregation for Indigenous peoples. The study and advice on the rights of Indigenous peoples to data, including data collection and disaggregation, discussed today is a timely and highly relevant document that underscores the central importance of data sovereignty for Indigenous peoples. It comprehensively outlines the existing legal frameworks, highlights the challenges and opportunities Indigenous peoples face in accessing and controlling data, and addresses the pivotal role data plays in realizing the right to self-determination, participation in decision-making processes, and the exercise of free, prior, and informed consent of Indigenous peoples. The report effectively explores the relationship between data and the right to development, governance, and sovereignty, and the inclusion of Indigenous women in data governance. It also provides a forward-looking perspective on the implications of technology and artificial intelligence for Indigenous peoples' rights to data. The report's recommendation on culturally appropriate data collection methods and the meaningful participation of Indigenous peoples in data processes establish a clear standard for inclusive, respectful, and rights-based data practices. These recommendations are vital for generating accurate and relevant data to inform public policies and programs that aim to enhance the well-being of Indigenous peoples. In sum, the report serves as a valuable roadmap for advancing equitable and just data systems that uphold and integrate Indigenous peoples' rights and knowledge systems. It is appreciated that the report references the Permanent Forum in the context of data disaggregation and the Sustainable Development Goals. To further strengthen the report, I have 3 specific suggestions that I will provide to you in writing. Thank you.
I thank the Chair of the Permanent Forum for your intervention. I now give the floor to the representative from Indonesia.
Madam Chair, Indonesia takes note of the EMRIP draft study and its timely discussion with regard to data collection and disaggregation in the context of promoting inclusive and participatory governance. We recognize that data is essential for equitable development and the realization of rights for all segments of society. We support efforts to disaggregate data to inform inclusive policy formulation. However, definitions and approaches must reflect each country's specific context and governance system. In Indonesia's national context, we are a multi-ethnic and multilingual nation. We are home to over 1,300 ethnic groups or tribes across 17,000 islands, which form a complex and diverse social fabric. Among these are Masyarakat Hukum Adat or customary law communities who have lived for generations in specific geographic areas and maintain strong ancestral ties. Instead of using the term indigenous peoples, Indonesia recognizes its internal diversity through ethnic plurality, as has been clearly articulated during the negotiation and adoption of UNDRIP. As part of this commitment, the government has conducted disaggregated data collection based on ethnicity through the 2020 population census. This census collected detailed information on first language, language use at home, and fluency in Bahasa Indonesia. It also includes demographic profiles by ethnicity, covering fertility rate, education, migration, and language use. These efforts reflect Indonesia's commitment to inclusive data governance aligned with national identity and cultural realities. Madam Chair, Indonesia is also a signatory to the WIPO Treaty on Intellectual Property, Genetic Resources, and Traditional Knowledge. This treaty marks a significant milestone in international law by acknowledging the rights of indigenous peoples and local communities and represents a positive step toward preventing the misappropriation of genetic resources and the traditional knowledge associated with them. Therefore, Indonesia supports their participation in data-related initiatives, provided such participation complements national systems and upholds state sovereignty. Finally, we emphasize that capacity building and technical cooperation are essential to ensure that all actors can engage effectively and meaningfully. Indigenous peoples, local communities, and other vulnerable groups must be heard, including through the data system that empower, protect, and reflect their voices. I thank you.
I thank the representative from Indonesia for her statement. I now give the floor to the representative from Encomin Dios. Mario Agreda, yes. You have the floor.
Gracias, querida presidenta.
Thank you, dear Chair, and the Secretariat of the Expert Mechanism. Would like to thank you for being here, and you are guiding this meeting in an excellent manner. Now we're looking at the historical memory of our peoples that our dear friend Celebrity was in prison for 51 years. We're continuing the struggle, and President Vaida has reaffirmed his conditional liberation. Now we'll see if it's actually possible when it happens. Now, distinguished sisters and brothers, it was here in the EMRIP in the years 2023, 2024, we demanded the freedom of our brother Leonard Lepertier. We have demonstrated that words have power. Words are the spirit, because it's not just simply committed, it's a way to live and understand freedom. We have dedicated many years for the just cause, for the freedom of our dear brother Liberté. His conditional liberation, confirmed by President Lebre, is a triumph, but it's not enough, because we continue to demand his full freedom, not conditional. And then other brothers that are still in prisons without true legal processes. And he was in prison for more than 51 years, and it runs counter to the values represented by the United Nations. Now, the conditions imposed by the government of the United States that you cannot have more than 3 persons visiting him. And also there are other things that I cannot express publicly. And he cannot travel more than 100 miles. And his new situation is still a cell. And the ex-president of the United States, Thomas Jefferson, spoke the same language and visited the houses of those. And this was not simply a sign of respect, the recognitions that the original peoples have already systems of government that are based on justice and liberty. And it was the constitution that led to democracy, inspired by these principles. The freedom of our distinguished brother is in line with historical situations, the principles that were adopted at the origin, the first step, the full absolution of Pelletier. Mr. Donald Trump, it is your turn now. We have to see what you actually do and not what you say. And you have to demonstrate it with facts, not with a conditional freedom, but full freedom. This is not just a single case. It is the cause of all the political prisoners of all peoples in the world that have been oppressed. Justice cannot be and should not be partial. It cannot be selective. Today, we are not simply asking, we're demanding to restore justice, and we are here to pay that debt in order to turn our words into actions and ensure the freedom of all. As the people of Senegal say, if you want to be sovereign, you have to act with sovereignty. It's part of our responsibility as we fight for freedom. This is what we are. It is on our end. And the Guarani population says, the soul and the world are the same. If I give you my word, I give you my soul. This is my world. This is me representing my people for the freedoms of all political prisoners throughout the world. Thank you very much.
I thank you for your intervention. I now give the floor to the Customary Council of New Caledonia.
Madame la Présidente, je vous félicite tout d'abord.
Madam Chair, I congratulate you on your nomination. And here I'd like to thank the Fund for Voluntary Contribution for Indigenous Peoples of OHCHR to contribute and make it possible for our participation here. New Caledonia that I represent here, I'm here to discuss the crisis that our country is facing, and it's still on the list of countries to be decolonized. New Caledonian is facing a post-conflict situation and facing a social and political crisis. The Mation and Nouméa agreements had made it possible to overcome the bloody events that took place recently, where the Kanak people reivindicated their legitimate rights and the right to self-determination as a people suffering from colonial oppression. The Nouméa Accords is a constructive agreement recognizing the identity of Kanak people, reflecting the Declaration on the Rights of Indigenous Peoples, focusing on autonomy and share of competencies between New Caledonia and France, and starting a process of self-determination based on resolutions of Geneva. And this all is related to the political of the state of France. Not all of the principles have been implemented, and the economic and social model of development been carried out by France in such a way that it marginalized the local population. The chaotic situation in the country and the high level of frustration of indigenous peoples. So we need to have international mechanisms that may guarantee the full implementation and respect of the agreements agreed between the indigenous peoples and states. Also, recommendations addressed to France are contained in the report of the Special Rapporteur NSERD of 2015 and 2022 have never been respected. It is imperative to ensure that the norms protecting indigenous peoples should become Jus Cogens norms, and we invite the expert mechanism to start thinking about a binding mechanism that can be established at the international level in order to ensure that states respect their commitments to indigenous peoples. In the case of the Kanak population, France respects the recommendations of the Special Rapporteur and the Human Rights Committee and the CERD and the Committee Against Torture. The collection of data should strengthen the sovereignty of indigenous peoples, and we call upon the mechanisms to urge states and recommend to France and European Union to ensure that free, prior, and consent should ensure that before collecting data, the prior informed consent should be ensured for indigenous peoples and guarantee their full and effective participation at all the stages of the process for developing and trend. And we invite the EMRIP to states and France to integrate data in state reports that are submitted to international bodies. The third, the expert mechanism to measure how the right to self-determination is being respected. To build local communities, we recommend to propose the states and UN agencies to fund and accompany the training of researchers, statisticians, and experts from indigenous peoples for them to carry out investigations and analysis and ensure participative research while promoting local values. And indigenous peoples await a strong response from the international community. Thank you.
I thank the representative from New Caledonia for your statement. I now give the floor to Consuelo de Lironicus Acroa Gamela for a joint statement.
Conselho de Lideranças Acroa Gamela com a Associação Indígena Socioambiental Curiça. Are you in the room?
La salud de los pueblos indígenas en
The health of indigenous peoples in Brazil needs to be addressed urgently. Invisibility means that we cannot address difficulties. We reiterate the emergency of guaranteeing the free, prior, and informed consent pursuant to Article 6 of ILO in all data collection involving indigenous peoples. For us, health also means biodiversity. We need to consider the various territorial realities of where we live. This right guaranteed by resolution of WHO and the general recommendation number 35 of the Committee for the Elimination of Racial Discrimination, CERD. Self-determination and the protection of our traditional territories is the subject thereof. It also recognizes in Article 12 of DESC is also relevant, of CESC rather. Lack of data, reliable data and ethical data and disaggregated data is also a problem. We must recognize the specificity of groups that encounter additional barriers. Pregnant persons, the elderly, persons with disabilities, and indigenous peoples, LGBTQI+. The violation of rights is ongoing and there is risk to life and health. We recommend to give priority to differentiated policies, to give priority to people who are vulnerable, with specific guidelines for the health of gestating women, the elderly, people with disabilities, and indigenous peoples who are LGBTQI, respecting traditional knowledge, and community protocols guaranteeing the inclusion of social determinants of health, drinking water, safe food, decent living, housing, and a healthy environment, and also as part and parcel of the follow-up mechanisms of the treaties. Thank you very much indeed.
I thank the representative for your intervention. I now give the floor to the Assembly des Armenians d'Arménie Occidentale.
Արգանդներս դիգին նախագահ, թող արամազդը լուսավորե ձեր ճանապարհը. Permettez-moi, Madame la Présidente.
Madam Chair, if I may extend to you my heartfelt congratulations. Since the most ancient of times, the history of the memory of humanity, namely the preservation of data and their disaggregation, has been an existential need, fundamental need to pass on knowledge and know-how to following generations, which is why the Armenians of Western Armenia have inscribed in the marble of humanity an alphabet whose every letter of whom has got a numerical equivalent. In 405, it was established by the theologian and hymnologist Hishlut Mashtoch from the Armenian character that was found on the territory of Western Armenia by a Syrian bishop called Daniel. Armenians appreciate appreciate their alphabet. It is a cultural miracle. But the most remarkable thing about the alphabet is its link with the periodic table published by the Dmitry Mendeleev in 1869. In other words, the sum of the indices of the alphabetical whose previous name of an element is the equivalent of the atomic number of this element, despite the fact this applies to this known element when it was invented, when the Armenian alphabet was invented. These are key elements such as gold, copper, silver, tin, mercury. If I take an Armenian, the speaker is establishing equivalence between the periodic table and the Armenian alphabet, the details of which are impossible to gather by the interpreters. It's very unlikely that the person who established this system did not know about these elements. We still don't know what rules Mashtots used in devising the current alphabet. Whether it's a coincidence or a miracle, Mashtots had a certain rationale in his mind, but the result is surprising. Indeed, Western Armenia is part of the first state in the world, even though it is not recognized by the United Nations, even if all of its territory is occupied by Turkey and its indigenous populations, which survived in 1895 genocide to date, cannot be heard within the Human Rights Council today. This is a demonstration and evidence of the possibility, the possible disaggregation of data for the memory of humanity if the descendants of the survivors of the Armenian genocide had not found the energy to reconstitute their linguistic heritage. This statement, this intervention falls under Article 13 of the Declaration. Thank you very much.
Thank you for your intervention. I now give the floor to the National Aboriginal and Torres Strait Islander Higher Education Consortium.
To congratulate Madam Chair on your election. My name is Alida Bailey. I am from Turkana Nation and Nipaluna Hobart in Lutruwita, Tasmania. I pay my respects to elders and ancestors of all Indigenous people here today. I'm here today as a representative of the National Aboriginal and Torres Strait Islander Higher Education Consortium and as a medical student representing the Turulaway and Payabeans people. The ongoing colonisation of Australia and internationally has resulted in the disturbed ability for Indigenous peoples to put sovereignty in place over our data necessary to survive and flourish. In 2020, the Australian Government implemented the Closing the Gap program, introducing 19 target goals to reduce disparities between Indigenous and non-Indigenous people in Australia. To date, just 4 of these goals are on track, while some are getting worse, including incarceration, child removal, and suicide prevention. Other goals have no data available. This reduction in data must improve to increase the equity of health access and thus outcomes among Indigenous peoples. Currently, the Australian Government and agencies collect data which is decontextualised, aggregate, deficit, restricted and blaming, meaning Indigenous peoples are unable to collect, analyse, manage and reuse data ourselves. This disempowerment of our rights to our data means there's a disconnect with data about us, therefore not always meeting the physical, cultural and spiritual needs of our people or their health. In the collection, interpretation and management of Indigenous data, Indigenous needs, worldviews and knowledge fail to be met and implemented. We have the right to demonstrate self-determination and leadership, exercising our right over data sovereignty to revitalise our culture and maintain our intellectual property as in UNDRIP Articles 11 and 31. The Australian Government should look to Mayam Nari Wingara, the Global Indigenous Alliance, the CARE Principles, and listen to their own people about these critical topics. Several nation states should be held accountable for the fact they have not acted and signed the WIPO Treaty. Though the WIPO Treaty is a step in the right direction, we do need to improve its lack of tangible benefits. And we urge nation states to implement the terms of this treaty by signing it. We recommend that health services must implement policies in which Indigenous peoples control data collection and how this is then implemented and reviewed by the Australian Government and services. Having accessible data which informs a comprehensive narrative, recognises cultural differences, social complexities, and addresses priorities. These will allow Indigenous peoples to reclaim data sovereignty and lead the data lifecycle. By Indigenous peoples leading data collection, access, and management, the government can rely on accurate, contextualized data to improve the Closing the Gap initiative and in turn improving healthcare and reducing the burden of disease on the Indigenous peoples in Australia. Thank you.
Thank you for your intervention. I now give the floor to the representative from Minority Rights Group.
Minority Rights Group would like to pass our congratulations to the EMRIP group mechanism for their draft study, which is detailed and covers important areas. MRG has experience of working with Indigenous partners and with UN entities to try to address the invisibilization of Indigenous peoples in data gathering, analysis, and reporting. We would strongly endorse the findings of the draft study concerning the lack of disaggregated data and the lack of meaningful participation of persons with Indigenous heritage in national statistical offices and other data gathering and analysis processes. Without this involvement, any attention to indigeneity in data and statistics is incomplete and risks being critically flawed. We would also want to draw to the attention of the experts and those in the room of the importance of international actors who are involved in statistical decision-making or have influence in such processes. UNICEF, for example, works with states to gather data through the multiple indicator cluster survey, for example, and bears the responsibility for ensuring that Indigenous and other groups at risk of marginalization are involved, give their consent, and have ownership of the process. Ultimately, the results of those exercises should lead to the identification of systemic discrimination which may prevent Indigenous peoples from accessing services and otherwise fulfilling their rights. Likewise, WHO has a mandate to provide health data about health globally, including differentials in access to health for different groups. How visible are Indigenous peoples in that data? We note that UNFPA, UNICEF and UN Women did publish a fact sheet in 2018 on Indigenous women's access to sexual and reproductive healthcare services. And we note that this work is currently in the process of being updated, with new analysis being expected later this year. This study could be a useful model for other UN agencies to consider emulating in their respective mandate areas. We note the important role of the interagency expert group on the SDG indicators and pose a question concerning to what extent states have nominated a person of Indigenous heritage to represent their community on that body or their state on that body. We would call on all present to redouble efforts to consider intersectionality, particularly concerning people with a disability within Indigenous communities who face multiple forms of disadvantage and are even less likely to see themselves and their situation reflected in national statistics. In a phrase coined by a Black Brazilian woman with a disability, I end by taking the liberty to remind all present that no data is data. When states opt to not gather data disaggregated by ethnicity, that's already making a statement about their values and their ability and willingness to meet their international commitments. Thank you.
I thank the representative from Minority Rights Group for her intervention. I now give the floor to the Resource Centre for Human Rights and Civic Education from Africa.
Thank you, Madam Chair. Distinguished experts, ladies and gentlemen. I'm Dr. Ibrahim Zikirullah, Executive Director of Resource Center for Human Rights and Civic Education. I'm joined by 6 delegates with the support of the John D. and Ketri team and Cato Foundation to bring a renewed urgent global attention to the worsening plight of the indigenous peoples of Nigeria's Federal Capital Territory, Abuja. Today, over 2 million indigenous people of Abuja, otherwise known as original inhabitants, representing 9 tribes and 17 chiefdoms, face systematic exclusion, land dispossession, political disenfranchisement, and cultural erasure. Without urgent and decisive action, these communities risk extinction. The roots of their suffering trace back to military decree number 6 of 1976, which forcefully appropriated their ancestral lands to establish Nigeria's new capital. Since then, successive governments have failed to provide compensation, resettlement, or legal recognition. Not even Supreme Court judgment affirming their rights have moved the Nigeria state to honor its obligations. In addition to the systemic marginalization faced by Abuja original inhabitants, we underscore the critical importance of data sovereignty and the right to data as a cornerstone of indigenous people's self-determination and development. Despite the existence of research by bodies such as UNESCO and UNICEF, affirming the presence and identity of indigenous people in the Federal Capital Territory of Nigeria, Nigeria government has failed to collect, disaggregate, utilize this data to inform inclusive policies. This omission perpetuates invisibility and exclusion in national development planning, budgeting, and service delivery. The consequences of this neglect are devastating. Abuja indigenous communities lack basic amenities, functional healthcare, quality education, clean water, sanitation, and infrastructure. Their traditional livelihoods, farming, fishing, hunting, and craftsmanship are endangered by unchecked urban sprawl and ecological degradation. Politically, they are denied fundamental rights. The indigenous people of Abuja cannot elect a governor or state legislature, rendering them stateless in their homeland. These injustices contravene both Nigeria's constitutional guarantees and its obligation under international human rights law, particularly the United Nations Declaration of the Rights of Indigenous People, which enshrines the rights of self-determination, cultural preservation, and land ownership. Therefore, we therefore call on this expert mechanism, member states and all relevant stakeholders to hold the Nigerian government accountable and to support the following urgent action. To formally recognize Abuja's original habitat as indigenous people with full legal status and protection, ensure their participation in democratic governance, including the right to elect local and regional representatives, enact inclusive policies that guarantee access to land, natural resources, and economic opportunities. Support grassroots initiatives to safeguard indigenous languages, traditions, and sustainable practices. Abuja's OI must have the right to control, access, and benefit from data concerning their communities' lands and resources. Without accurate and inclusive data, the lived realities of Abuja original habitat remain obscure, and their rights continue to be denied. Data is not just a technical tool, it is a vehicle for justice, visibility, and empowerment. The survival of Abuja original habitat, the preservation of their identity, dignity, and heritage depends on urgent and coordinated intervention. Development must never come at the cost of dispossession of cultural institutions. Let us act now. Justice delayed is dignity denied. Thank you.
Thank you for your intervention. I now give the floor to the Indigenous Peoples Rights International.
Thank you, Chair. The Indigenous Peoples Rights International is pleased that the EMRIP has decided to develop a study report on data collection, and disaggregation. As outlined in the report, data plays a significant role in achieving the right to self-determination. It also stresses the importance of free, prior, and informed consent when it comes to data collection regarding Indigenous peoples. Data sovereignty is key to the control and access of our own data, and therefore should be the forefront of data collection, verification, and analysis. For far too long, data and research has been collected on Indigenous peoples by non-Indigenous peoples, entities in harmful ways that have been used to make assumptions and determine decisions about us without us, including access and control over our lands, territories, and resources. Indigenous Peoples Rights International is an indigenous-led organization that collects, verifies, and analyzes data relating to human rights violations and criminalization against Indigenous peoples globally. As suggested in your report, the need for indigenous-led data is significant to the outcomes of data, including building trust and reciprocal relationships with Indigenous peoples and communities. We at IPRI also express the same as we recognize the stories, experiences, and perspectives of information we receive given to us in the act of trust when it comes to data on criminalization and other human rights violations. On June 18th, Indigenous Peoples' Rights International held an online conversation with 3 Indigenous-led organizations who also shared their experiences of both challenges and opportunities regarding data collection, verification, and data sharing. A challenge that reflects both in the report being presented today and the conversation we had is the role of the data producers, including state-driven, when it comes to disaggregation that plays a significant role in the outcomes. As suggested in our online conversation, we also want to highlight the shrinking of online civic space and state surveillance that affects Indigenous peoples, organizations, and human rights organizations in the security of data collection, specifically in states where exploitation of land and resource extraction is significantly high. Our 2024 data shows an increase in non-lethal attacks, including land grabbing, forced displacement, criminalization, arbitrary detention, and state-sponsored devilification of Indigenous leaders and communities coming from those areas of exploitation. These findings are critical to evidence-based advocacy, and IPRI is grateful for the trust that is given to our data in our data collection directly from communities. It is important to recognize the capacity that is required to collect data and stewarding data, and therefore we would like to recommend the expert mechanism to develop a study on violence and criminalization affecting Indigenous peoples in the exercise of their rights, including the consideration of data collection and verification on these issues by Indigenous peoples themselves. The expert mechanism to advise states and other relevant actors to support Indigenous peoples' own initiatives in data collection, verification, and custody, particularly regarding the violations of their individual and collective human rights that can ensure the adoption of necessary laws and policies to effectively address this situation. Thank you.
Thank you for your intervention. I now give the floor to the Congress Amazigh.
Merci, Madame la Présidente.
Thank you, Madam Chair. Honourable Assistants. Our Congress sincerely congratulates the members of EMRIP for the preparation of this study on the Indigenous peoples in connection with data. Our organisation considers that this topic and the way in which it is dealt with in this study are relevant, very relevant, and have a concrete usefulness to our peoples, because it strengthens the fundamental principles of Indigenous peoples, such as the right to free, prior and informed consent, the right to self-determination, and the right to sovereignty of Indigenous peoples over their data, over their knowledge, and over their territories, their land and their resources. For us, the Amazigh, this study is a clarification and a comprehensive response based on international law, a response to the bad practices of governments in North Africa who continue to pretend that we do not exist, to grab our lands, our resources, and falsifying our data. The police and administrative bodies constantly gather data on us without our consent or without our participation, and we have no access to this data, which is collected about us by governments, seriously violating our right to privacy and seriously violating our fundamental rights. To illustrate my speech, let me just give you one example, namely the census of the population carried out by Morocco and Algeria. The last censuses use questionnaires which exclude indigenous languages, and the method used to question people is clearly designed to reduce the number of Amazighs in the countries. In Tunisia, the 2024 census merely forgot to ask the question to know who is an Amazigh in that country and who is not, as a result of which the result of the census says that there are no Amazighs in Tunisia because no one self-identified as an Amazigh, and the question wasn't asked of the people who were questioned for the survey, for the census. Finally, on the same issue of the rights of Indigenous peoples to the data, everything rests upon the goodwill and the sincerity of governments to cooperate in order to respect the rights of Indigenous peoples, to achieve. That is why we very much rely on EMRIC and the other UN mechanisms to act always in order to secure effective cooperation and good faith from governments. Thank you very much.
Thank you for your intervention. I'd like to now turn to my colleagues on the expert mechanism to see if you had any comments or feedback. I recognise expert member Ms. Lightfoot, please.
Thank you very much, Chair. And since this is the first time I'm taking the microphone, I want to take this opportunity to thank you and the previous vice chairs for your very effective service and leadership of the EMRIP in the past year, and to offer my heartiest congratulations to the incoming chair and my co-vice chair. And I look forward to working together with all of you in the coming year. I would also like to sincerely thank all of the speakers today for the depth and some of the clarity brought to the conversation. And the messages that we've heard from the floor today really affirm the fact that is obvious to us, which is data is never a neutral concept. It, in the hands of others, it can reproduce a multitude of colonial harms. But when in the hands of Indigenous peoples, it can become a powerful tool of our self-determination. We've heard very strong and consistent calls from the floor to center Indigenous data sovereignty in order to ensure that Indigenous peoples are not only counted, but are in control of how, when, and why data is used and collected. And several interventions have reminded us that disaggregated data, when gathered without consent or without safeguards, can cause real harm. And so we need to be mindful of that. So ethical standards, full participation, and respect for Indigenous governance are not just optional, they are essential. And we will make sure to highlight that in our final version of the report. And we're especially moved by those who spoke from situations of conflict and repression and isolation. And your testimonies remind us that data can also be a matter of survival and of dignity. And finally, we want to welcome the many concrete suggestions and edits that have been shared with us today and that will be shared with us in writing. We accept both, so we appreciate that very much. And we reaffirm our commitment to reflect on these in our study and recommendations. So thank you very much.
Thank you, Ms. Lightfoot. Are there any other members that would like to provide some comments before we close the session? I see none. I would also like to thank all the contributions from the floor. It provides a rich tapestry for us to consider as we finalise our draft study. For those of you who weren't able to take the floor, please do send your intervention in to us. They're all important and we value them highly. So with that, I'll close our item 3 and before we move on to the next country engagement item. Thank you.
Братья и сестры, позвольте вновь.
Sisters and brothers, I would like to once again greet you here during the 18th session of the Expert Mechanism of the United Nations on the Rights of Indigenous Peoples.
Братья и сестры,
Sisters and brothers, I would like to once again welcome you to the next meeting of the 18th session of EMRIP. For me, it is a great honor to chair this discussion of the work of the expert mechanism with states in line with point 2 of the resolution of the Human Rights Council 33/25. The expert mechanism provides technical consultations, promotes dialogue, and carries out interaction at the level of countries at the request of member states or indigenous peoples. The most effective in all of this are requests that are being supported by both stakeholders, both states and indigenous peoples. And the forms of interaction may include technical assistance in development of legislation and policies, contributing to the implementation of recommendations that were prepared during the process of the UPR, recommendations made by treaty bodies, special procedures, and other international and regional mechanisms. The promotion of dialogue between indigenous peoples, states, and the private sector, independent monitoring of compliance with the law and policies in the realization of the provisions of the UN Declaration on the Rights of Indigenous Peoples, promoting the potential of interested stakeholders and increasing awareness of the declaration and international standards. Since 2017, the expert mechanism has undertaken 7 country missions, including Western Australia in 2023 and Norway in 2024. We continue to engage closely with those who request assistance and states to shape future engagements. These efforts are guided by the thematic studies and reports of EMRIP, lessons learned, and follow-up steps with stakeholders involved in past missions of the expert mechanism. Unfortunately, due to current financial constraints in the United Nations, EMRIP was forced to cancel the mission that was planned to Brazil in September 2025. However, the expert mechanism remains fully committed to the mandate and is exploring flexible approaches to ensure meaningful engagement, as we have done in the past in cases such as the Masokova repatriation or during the pandemic. We'd like to draw your attention to the fact that engagement modalities are not exclusively related to country missions. We are considering other requests, including those related to the right to consultation, free, prior, and informed consent, and as well as the finalization of a national action plan for the implementation of declaration. I just mentioned a few of those types of requests, and obviously there are others. We encourage states, indigenous peoples, and the private sector to engage with EMRIP to pursue country mandates. Today's panel brings together representatives of indigenous peoples and states to discuss the implementation of the most recent technical advice made by EMRIP following missions to Norway and Australia, what worked, what we saw progress, where we saw progress achieved, and what challenges remain. We know that implementation is an ongoing process requiring sustained commitments and cooperation. So we will first begin with our country engagement mission to Norway. We're pleased to welcome the representative of Norway, as well as the representatives of the Sami Council and the Sami Parliament, who jointly requested the expert mechanism to carry out that mission. They will share their perspectives on the outcomes and the impact of the mission of EMRIP for the Sami rights holders. And the state will also provide an update in light of the technical advice provided by the expert mechanism, which will address key issues including self-determination, free, prior, and informed consent, and the implementation of domestic court rulings and treaty bodies' decisions concerning the rights of the Sami people in Norway. The expert mechanism is aware that the technical advice note has generated discussions, particularly with respect to the application of the international standard of free, prior, and informed consent. EMRIP appreciates detailed clarifications provided by Norway regarding its domestic consultation procedures, and we welcome the consultations underway with the Sami Parliament to improve regulations on impact assessments and consideration of cumulative effects. At the same time, EMRIP reaffirms its interpretation of free, prior, and informed consent as an international norm and safeguard necessary in cases where substantial rights are at risk. Or, as former Special Rapporteur James Anaya stressed in his 2011 report on extractive industries, saying that if there is a potential for serious or irreparable harm to indigenous rights and interests. In this context, the term full consultations in the advisory note is intended to denote consultations that align with the rights to free, prior, and informed consent. In the advisory note, the expert mechanism refers to free, prior, and informed consent, not as a procedural formality or a duty to hold consultations. This standard reinforces the right to self-determination, land, culture, and livelihoods, and also entails the meaningful participation of affected communities of indigenous peoples in decision-making through their own organizations and representative institutions before any investments, approval, or the launching of any project affecting their lands, territories, or resources. In this spirit, EMRIP's advice encourages continued dialogue between Norway and the Sami people to ensure that Norway's legislation and practice progressively align with customary and conventional international law in relation to free, prior, and informed consent and the implementation of related rights of the Sami people. Also today we will hear about the 2023 mission to Australia undertaken in response to concerns about the forcible removal of Aboriginal children from their families and communities in Western Australia. The Nungar Family Safety and Wellbeing Council, as the requester, will provide follow-up information on the outcome and significance of the mission and how it contributed to efforts to protect Aboriginal children. Australia will share steps taken in response to the advice provided by EMRIP, including legislative, policy, and pragmatic measures aimed at addressing the systemic intergenerational harm associated with the removal of Aboriginal children. The discussion will highlight 4 key themes: self-determination, forced assimilation, discrimination, and the 2021 amendment and removal of children. The recommendations of EMRIP have been agreed with the conclusions of the treaty bodies. For example, the recommendations of the CERD to establish the positions of Indigenous Child Commissioners for each state and territory. EMRIP also recommended the appointment of more Indigenous judges and a broader shift in the overall approach in child warfare, emphasizing the application of the right to self-determination. The recent information received by the CERD Committee Urgent Action Procedure concerning Indigenous children in the criminal justice system highlights the timeliness and continued relevance of EMRIP's country engagement in Australia. Indigenous children continue to be disproportionately incarcerated and suffer from long-term adverse health impacts in custody. EMRIP is convinced that the implementation of recommendations related to legislative policy and structural reform will have a positive systemic impact on the well-being of Aboriginal children in Australia. After hearing from the panel members, we'll invite comments and questions from EMRIP members. After that, we will turn to the list of speakers. We welcome all of you to provide us with any updates from past country engagements or invitations for future ones. We now look forward to hearing the views, lessons, and reflections from our panelists. And I would like to start by inviting the representative of the Sami Council, Eric Larson. You have the floor. You have 8 minutes.
Thank you, Chair. The Sami Council welcomes the technical advisory note of the expert mechanism from the country engagement mission to Norway. As the requester of the country engagement, the Sami Council extends our gratitude to the expert mechanism for its visit and to the Norwegian government for accepting the visit. A special thanks to the Sami Parliament in Norway for the cooperation during the planning and execution of the country engagement. We also warmly thank the Sami right holders and others that contributed for their valuable contributions and for the productive meetings. The context of our request to EMRIP was the significant and accelerating interest in industrial development projects on Sami lands, including wind power projects, hydropower dams, and extractive industries. These projects are often in direct conflict with Sami livelihoods and areas essential for the existence of Sami culture. As a result, the Sami people are not only affected by the climate change itself, but also by land encroachments justified by the Nordic governments and companies under the urgent need for a green energy transition. In this context, the government of Norway has authorized a significant expansion of industrial activity on Sami territory. Numerous large-scale land encroachment projects are underway or in planning. In our view, many of these projects violate the land rights, cultural rights, and property rights of the Sami people. These development projects have increasingly given rise to conflict between the Sami people and the government. Such conflicts have manifested in litigation, public demonstrations, and acts of civil disobedience, reflecting the growing urgency and gravity to the human rights implications at stake. In our experience, Norwegian legislation is not sufficient to protect the Sami people in these matters. The most prominent case to this date concerns the wind power project in Fosen and the Norwegian government's subsequent failure to implement the Supreme Court's decision. In this judgment, the Supreme Court found that the construction and operation of the wind power facilities violated the rights of the Sami reindeer herders as protected under Article 27 of the International Covenant on Civil and Political Rights. We consider this case illustrative of a broader pattern, particularly given that only months before the Supreme Court's decision, the government dismissed the possibility that land encroachment in Norway could amount to human rights violations against the Sami people. In the preparatory works for the Norwegian current consultation rules, the government acknowledges that in cases involving threats to the interference with traditional livelihoods of the Sami people, the free, prior, and informed consent is mandatory. But the ministry states the following, I quote, "The ministry assumes that it will take significant circumstances for this issue to become critical in relation to intrusions into Sami culture. The authorities already have an obligation to assess the impact of measures that may affect Sami culture. In such assessment, the authorities must consider the cumulative impacts of various measures in the relevant area. On this basis, the ministry believes that it's not necessary to introduce separate rules on free, prior, and informed consent in cases involving serious encroachments on essential aspects of Sami culture," unquote. Chair, the government submitted this language as part of a legislative proposal to the Parliament of Norway only a few months before the Fosen case Supreme Court decision. The reason we believe that more such cases exist is that right holders often lack the capacity to pursue land encroachment cases through legal channels. This gives us reason to believe that the Fosen case is not an isolated incident. In our view, the Fosen case highlights the need to implement the right to free, prior, and informed consent in Norwegian legislation. So that was the backdrop of our request to EMRIP. Upon receiving the EMRIP advisory note, we find that it confirms our concerns. The report highlights significant gaps in Norwegian legislation related to land encroachments and recommend legislative reforms to bring national law in alignment with the Declaration on the Rights of Indigenous Peoples. Key recommendations include strengthening Sami self-determination, ensuring the inclusion of free, prior, and informed consent, abolishing the practice of advanced possession, and providing education for public officials, as well as capacity building within the Sami community. We also believe that the report holds global relevance and encourage both indigenous peoples and member states to consider its finding within their national and local context. Chair, the Sami Council would like to highlight the valuable expertise of the expert mechanism and its vital role in advancing the implementation of the Declaration on the Rights of Indigenous Peoples, as reflected in EMRIP's mandate. We respectfully call on the Norwegian government to acknowledge this expertise and to give careful consideration to the report and its recommendations. The process represents a meaningful opportunity for Norway to strengthen the protection of the Sami people in Norway. In this regard, we look forward to concrete and constructive follow-up to the advisory note guided by EMRIP's recommendations. We trust that the follow-up will reflect a commitment to concrete right-based implementation of the declaration with meaningful collaboration between the government and the Sami people at its foundation. Thank you for your attention.
Спасибо большое за...
Thank you very much for your statement. Our next speaker is the President of the Sami Parliament in Norway, Silje Karin Motka. We'd like to listen to your views and your analysis related to your interaction with Norway. Thank you.
Distinguished Chair, members of the expert mechanism, Excellencies, Indigenous representatives, and colleagues. I am honored to address you today on behalf of the Sami Parliament of Norway in response to the technical advisory note issued by the expert mechanisms on the rights of indigenous peoples following its country engagement mission to Norway. First, let me express our sincere gratitude to the expert mechanism for its thorough and thoughtful work. The mission, conducted in March 2024, provided a vital opportunity for a dialogue between Sami institutions, the Norwegian state, and international human rights bodies. We especially appreciate the focus on the interconnected rights of the Sami people, our rights to our land, territories, resources, culture, and self-determination. The advisory note highlights several critical areas where Norway must take further steps to fulfill its obligations under international law, including the UN Declaration on the Rights of Indigenous Peoples, ILO Convention 169, and the International Covenant on Civil and Political Rights. We welcome the expert mechanisms emphasize on the right to free, prior, and informed consent, while the 2021 amendments to the Sami Act improved consultation procedures in some regards may be seen as a positive improvement. The Sami Parliament agrees with the expert mechanism that these measures remain insufficient as how they so far have been practiced. The Sami Parliament of Norway would like to emphasize the importance of that the core principle of FPIC should be better integrated into Norwegian law, not only as a procedural formality, but as a substantive right that ensure Sami communities can meaningfully influence decisions affecting our lands and livelihoods. The report rightly draws attention to ongoing concerns regarding extractive industries, particularly in relation to the Fosen wind power project and the planned mining site at Repparfjord. These projects have been proceeded despite Sami opposition and in some cases in violation of court rulings. We echo the expert mechanism's call for Norway to implement judicial decisions and to ensure that Sami rights are not overridden by economic interests. We also support the recommendation to review and revise key legislation. Norwegian laws must be aligned with international standards and must guarantee Sami participation and benefit sharing. The Sami Parliament is ready to contribute constructively to these legislative processes. Furthermore, we appreciate the call to strengthen the legal recognition of traditional Sami livelihoods, including coastal fishing and reindeer herding. These are not only economic activities, they are the foundation of our culture, identity, and way of life. Finally, we welcome the recommendation to continue the dialogue between states and the Sami parliaments regarding the ratification of the Nordic Sami Convention. While some minor but essential adjustments still need to be made, this treaty is important for safeguarding Sami rights across national borders and for promoting cooperation between Sami parliaments in Norway, Sweden, and Finland. The Sami Parliament of Norway would like to re-emphasize, as stated in my speech in this assembly last year, that the rights and land areas of the Sami in Norway are being subjected to ever-increasing pressures. This tendency is a major area for concern for the Sami Parliament. This situation has accelerated in the meeting with the Norwegian government's policy of green energy that takes our land rights and pristine nature as a commodity and for granted, something to sacrifice for the greater good of Norwegian society. Chair, colleagues, the Sami Parliament of Norway remain committed to working in partnership with the Norwegian government and international mechanisms to advance the rights of the Sami people. We urge Norway to take the recommendation of this advisory note seriously and to act with urgency and integrity. Let us remember, indigenous rights are not optional. They are binding obligations rooted in justice, dignity, and the right to exist as distinct peoples. Thank you, Ologito.
Благодарю Совет Саамов и
I'd like to thank the Sami Council and the Sami Parliament for that statement and the fact that Norway and Sami are carrying out a dialogue on reforming the legislative situation in the country reflects the true nature of existing procedures. Right now, I'd like to give the floor to the representative of Norway, Bjorn Olof Megard, Director General, Ministry of Local Government and Regional Development. You have 15 minutes, sir.
Thank you, Honorable Chair. Norway welcomes this opportunity to respond to some of the issues raised in the advisory note, resulting from the EMRIP's country visit in Norway in March 2024. I'm glad to have attended the panel on country engagements last year. I'm pleased to return to elaborate on our positions. I will begin by highlighting some important examples of where Norway and the expert mechanism have similar views. In paragraph 61 of the technical advisory note, the EMRIP states that free, prior, and informed consent, FPIC, is, quote, not achieved in a single moment or action, but rather it is a process of dialogue and negotiation over the course of a project, end quote. The EMRIP continues to emphasize that the combined terms consult and cooperate, used in the UN Declaration on the Rights of Indigenous Peoples, UNDRIP, quote, denotes that a right of indigenous peoples to influence the outcome of decision-making processes affecting them, not a mere right to be involved in such processes or merely to have their views heard, end quote. And further in the same paragraph that, quote, indigenous peoples must also have the ability to make an alternative proposal or suggest different models, end quote. The EMRIP also refers to the Human Rights Committee's elaboration that indigenous peoples' participation in decision-making processes must be effective. This understanding of consultations and cooperation is very similar to what is codified in Norway's Sami Act, Chapter 4. The system in the Act, with agreement or consent as the obligatory purpose of the process, is clearly a more cooperative process than what is referred to in the advisory note, paragraph 78A, as, quote, a mere right to be consulted, end quote. Also worth mentioning, if there is a disagreement on whether or how the law requiring consultations applies in a particular circumstance in Norway, the matter can be raised in administrative complaints or be brought to regular domestic courts. In the advisory note, the EMRIP recommends several measures that are in fact already in place in Norway. For example, the need for training local and central government employees and politicians. Measures are already in place, they include written guidance and competency building courses. Another example is that our domestic legal order with impact assessments followed by assessments in the agencies and ministries already provides the necessary requirements to satisfy the content of impact assessments as described by the EMRIP in paragraph 72. There is also already a requirement to include analysis on cumulative effects on land interventions, which is important, as emphasized by the EMRIP in paragraphs 52, 63, 64, 76, 79, and 80. We agree. However, in paragraphs 72 and 79, the EMRIP recommends that rules and procedures for impact assessments and the knowledge base for land use cases should be improved. As the delegation was informed of during the visit, work has started on possible improvements of the regulations on impact assessments. The Ministries on Environment and on Local Government have jointly consulted the Sami Parliament on the draft new regulation and will consult further. The plan is for the regulation to go out on a public hearing by the end of this year. Chairperson, I now turn to some aspects of the advisory note where we respectfully have different views and interpretations, both on whether domestic legislation should be amended and on the obligations under international law. The EMRIP suggests in paragraphs 75 and 78A of the advisory note that Norway should enact provisions on consultations into other laws, such as the Energy Act or the Mineral Act. In our view, that would be unnecessary duplicative legislation, as the relevant provisions are already enacted in the Sami Act. There are no plans to do so, as duplicative legislation is generally disfavored in the Norwegian legal system. Having the same rules in different statutes makes it more challenging to keep the rules consistent over time and when amendments are needed, or when only one statute is applied and interpreted in court. More concerning, the wording of paragraph 66 of the advisory note implies that agencies or ministries give licenses or permits or concessions for land use interventions, quote, before full consultations are conducted, end quote, or, quote, before full assessment of cultural, environmental, and socio-economic impacts is made, end quote. As we have communicated in writing, this is factually not correct. Please allow me to clarify. The system for granting licenses, as obliged by law, can be summarized in 5 phases. The first phase is a licensing process and a decision at the agency level. For example, the Norwegian Water Resources and Energy Directorate or the Directorate of Mining. The second phase then is the possible appeal of the decision, which is decided by the relevant ministry. The ministry may try all aspects of the case, including the exercise of discretion. The third, sometimes partly concurrent phase is that the business enterprise in question acquires the necessary private rights, if needed as a mandatory sale, called expropriation. The fourth phase is, while the compensation is made for the mandatory sale is being determined, the enterprise can get permission to start building, that is a decision on advanced possession, or forhåndstiltredelse in Norwegian. Then the fifth and final phase is determining the price for the mandatory sale, if necessary, by an appraisal court. All 5 decisions mentioned here can be challenged in court throughout the process, which includes thorough assessments, dialogue, and consultations. There is no need to wait until phase 5. Even in the 5th phase, when the installations may have already been built, the right holders can make a claim in appraisal court that the underlying license is legally invalid because it violates the human rights of right holders. At this point, the right holders may make that claim without running the risk of being held liable for litigation costs, as the expropriating party is obliged to cover all necessary costs. It rarely happens that a license is deemed invalid by the courts, but it notably did happen in the Supreme Court's decision on October 2021 regarding the wind power plant at Fosen. Unfortunately, some sources have translated the name of the 4th phase, advanced possession, into pre-permitting in English. This might have led to a misunderstanding that advanced possession may happen earlier in the process. It may not. Advanced possession only happens prior to the 5th phase, that is determining the compensation for and the final processing of a mandatory sale. Either way, let me be clear, agencies and ministries have the duty to make all impact assessments and human rights assessments before they grant any license. The consultation processes must be initiated early in the planning phase, long before any license is granted. This means that the advice in paragraph 76 in the advisory note is already the law codified in the Sami Act section 4.6, which states that consultations shall begin early enough to give the parties a genuine opportunity to reach an agreement. Finally, Chairperson, some comments regarding the interpretation of international law. The EMRIP appears to take the view that FPIC is always a requirement when land use decisions are affecting areas traditionally used or owned by persons belonging to an indigenous people. Norway has a different legal view, as acknowledged in the terms of reference for the country engagements. Norway's view is virtually the same as the views taken in Section 3 of the report by an expert committee of the International Law Association. It was presented to the Sofia conference in 2012, and the relevant part analyzes the wording of UNDRIP Articles 19 and 32.2. Norway's legal view on this topic can be summarized in 3 points. 1. There is not a general right of veto in land use cases, but always a duty on the state to make a real effort, in good faith, to reach agreement or FPIC. 2. Achieving consent is more important in more severe circumstances. 3. In extreme cases, like relocation or when lack of consent would lead to other human rights being violated, achieving FPIC becomes mandatory. The third point corresponds to the Puma decision from the Human Rights Committee. A requirement to reach agreement or consent whenever land development impacts indigenous peoples cannot be deduced from that opinion. Former Special Rapporteur on the Rights of Indigenous Peoples, James Anaya, phrased it similarly in his 2013 report on extractive industries, stating that conclusions, quote, consultations should take place and consent should at least be sought, even if consent is not strictly required, end quote. Norway's assessment of these international legal obligations was described to Norway's Parliament in 2021 in a proposition presenting the law proposal on consultations. The Sami Parliament agreed to this assessment of the international legal obligations during the prior consultations on the law proposal. In paragraph 73 of the advisory note, the EMRIP refers to the two constitutive elements of customary international law. It suggests that there may exist obligations of customary international law in relation to FPIC. In the opinion of Norway, there is no sufficient opinion juris expressed by states, nor relevant state practice, establishing international obligations relating to FPIC going beyond the obligation that is referred to in the above. Furthermore, the assessment of the Norwegian government is that our existing laws strike a reasonable and fair balance between the various societal risks at stake. We maintain that our domestic law, that is the Human Rights Act, in combination with the Sami Act on consultations and cooperation with the Sami and on the duty to aim for consent, is in accordance with international law. Given the amendments in 2021 in the Sami Act, Norway has fully implemented the 2018 recommendation on this issue from the Human Rights Committee, referenced in paragraph 10 in the advisory note. To summarize, this means that the Sami right holders and interests are involved from an early stage in all land use projects that may affect them directly. It also means that all parties should seek to find common ground and practical solutions. Whenever possible, a particular responsibility lies with the government agencies and ministries to strive to find agreement or consent. We thank the EMRIP for the interesting and respectful conversations we had during the country visit. Let me reiterate Norway's commitment to protecting and promoting the rights of indigenous peoples globally and in our own country. This statement will be available on the website of the Norwegian Mission shortly, and through DOSIP with footnotes. I thank you for your attention and look forward to your questions and comments.
Благодарю уважаемых панелистов. И сейчас...
I thank our speakers. Australia is next. I give the floor to the party Anna McBlade, who submitted the complaint to represent the Council for the Safety Wellbeing Council, the Nungar Family Safety Wellbeing Council. If you could kindly give us a roundup of the situation following the 2023 visit of EMRIP. You have 8 minutes. Please go ahead.
Thank you, Chair. The EMRIP country visit in 2023 offered the Nungar and wider Aboriginal community, as well as state and federal government, a significant opportunity to reflect on a most serious issue affecting Aboriginal people today, Aboriginal child removals. This issue stems from Australia's assimilationist history that sought to end the Aboriginal people as a race of people, and in Western Australia targeted all Aboriginal children of mixed race descent. For over 100 years, children were removed under colonial laws and taken from their families to be raised in missions and foster homes where widespread abuse and trauma was the common experience. This shocking history has only just been recognised by the state government of West Australia, who announced in June a redress scheme for the survivors of the stolen generations' history. Most of the survivors have long passed away, and the redress will never be able to repair what was found in the Bringing Them Home inquiry of 1996 to be a genocidal history. Today, all governments commit to closing the gap on Indigenous disadvantage but we are seeing disadvantage increasing in three main areas: child removals, incarceration and suicides. Australia is failing to progress the implementation of the UN Declaration on the Rights of Indigenous Peoples and has endorsed instead economic empowerment as a key policy. However, there's no evidence this policy will address disadvantage for most or address child removals, incarceration and suicide. Following EMRIP's visit, there have now been 5 Aboriginal community-controlled organisations recognised and supported to play an active role in child protection. This means there are now 6 Aboriginal representative organisations in total, and due to a policy commitment that was urged by Aboriginal leaders and spanning back a decade. We've also seen increased support for the Aboriginal Children Court program, Danju Bidiak, and the appointment of an Aboriginal magistrate to the court. However, there's been inadequate attention to the EMRIP country visit report and no roadmap forward towards implementing these important recommendations. The role of the Aboriginal organisations in child protection must be increased. At present, the statutory department
you.